This is the George Washington House, which is right across the street, C Street, Alfredo, Washington, number 42, which is our neighbor, Mr. Tobler Wallace. Mr. Wallace is the lawyer administration office here, Washington Bar Association lawyer's office at number 42. This is 56. As you can see, the number 42, as you can see, increments just like on Southwest Basin Street, and the increments on the same service that they got. This is George Washington House, originally the George Washington House, and they have this on administration office here in Alfredo, Washington, Southwest Jetnifer and Dana Garth, and also their prosecutor's office, which is faxed from to Annie Miller's office, Annie Miller at CO Benton, Washington, U.S. Services they provide for Dana Garth, and services they're at Superior Court, District Municipal Court, and Appeals office, and all in one. This is the C Street. Now, Tabler Wallace is the neighbor next door. Tabler Wallace has an administration office here, right across the street, which is Greater Courthouse. Respect. This is the George Washington House here in Fred Washington on C Street. Got this on live YouTube, Facebook, and 180 apps. CNN, ABC, Kennewick, Richmond, Pasco, Ephrata, Moses Lake, Lamb Weston's in Kennewick, Richland, Pasco, all refrigeration plants, all shipping CDLs, Department of Licensing here in Clearwater and Kennewick, Department of Licensing in Moses Lake, Washington, Department of Licensing in Moses Lake, Washington, Ephrata, Washington, Kennewick, Clearwater, Washington, and Andy Miller's office, and also Dano Garth Administration Office, because we faxed information to Garth, Dano, and Stephanie from Moses Lake Police Department. So we return these. This is Supreme Court, May 23rd, 2009. Case number is 953473 in Guerrero. May 23, 2019. Case number 958271. Braga Fergar versus Prieto Marasco. May 16, 2019. Case number 959056. State versus Romero Ocha. May 16, 2019, case number 960178, State versus Morgan. And this is now we'll continue on. This is May 18, 2019, case number 781073, Mount Zion Lutheran Church Appellate versus Church Mutual Insurance Company, respondent. May 25th, 2019, case number 77862. This is case number 77862-5, John T. Scott, descendant appellant versus Department of L&I, respondent. May 20th, 2019, case number 77752/1, Carl Longless, respondent versus BNSF. This is the railroad company, appellate. This is Division 1, May 20, 2019, case number 7644446, the estate of William Taylor Patrick Carell, respondent versus Reuben Taylor Jr. May 20, 2019, case number 76793-3, Baker Atlas. This is Resident Cross App versus Princess Chantar App / Cross Resident. May 20th, 2019, case number 768093, Sawyer Lake Veterinary Hospital, ETNU Apps versus Pine Tree Veterinary Hospital. This is May 20th, 2019, case number 77100-1, State of Washington respondent versus Cole Calvin Raymond Appellate. Let's go. May 20th, 2019, case number 78034-4, Deborah Hollis, pilot of Snohomish County Medical Examiner Office, responded. May 20th, 2019, case number 78171-5, Lawrence T. Cartnell, pilot versus United Services Automobile Association, responded. May 20th, 2019, case number 78215-1, Candine Buyer Ale Apps, Tel resident. May 20th, 2019, case number 79076-5, Ronald Brett Appellate State Washington ETA Respondents. Division 2. Division 2, May 7, 2019, case number 49038-2, Spinaker Ridge Community Associate Respondent versus Christopher Guest ETA Appellates. May 21st, 2019, case number 489422, Tiffany Kelso, ETA Respondent Cross App versus Olympia School District AL Appellates. AL Appellates. Respondents. May 21st, 2019, case number 50972-5, State of Washington Respondent versus Timothy Patrick Walsh Appellate. May 21st, 2019, case number 511720, State of Washington Respondent versus Kenneth Allen Walker Appellate. This is Division 3, May 12, 2019. This is Washington State, here in Alfredo, Washington, George Washington House. And as you see on the wall, it says May 12, 2019, case number 353397, Brooke Howe versus Department, and 39T is Social Health Services. May 21st, 2019, case number 358411, State of Washington versus Edward Lee Jogum. May 23rd, 2019, case number 358429, Dwayne Young, ETA Toyota Motors Sales USA. May 23rd, 2019, case number 36086-5, and pro-sentence review of Lean Mary Hardy. Division 3, May 16, 2019, case number 356761, Power of Electric, INC, Department of Labor Industries. May 16, 2019, case number 355071-1, State of Washington versus Larry Edward Siltman. May 16, 2019, case number 36031-8, State of Washington versus Joan Summers Magus. May 21st, 2019, case number 357058, State of Washington versus Bradley Dean Zimmer. May 21st, 2019, case number 35765-1, State of Washington versus Manuel R. Guzman. May 21st, 2019, case number 35795-3, and the marriage of Allison and Raul Markey Jr. May 21st, 2019, case number 35830-5, State of Washington versus John Paul Saunders. May 23rd, 2019, case number 36147-1, State of Washington versus Freedom TJ Morgan Flash. May 23rd, case, this is District 3, May 23rd, 2019, case number 36200-1, Vivian Loomis Family, LLC versus Jeffrey Bell, ETUX, ETL. Let's go over some table of contents. This is the table of contents. Contracts, May 24th, 2019. Biochemics, INC versus Access Reinsurance Company. Contracts, Insurance Law, U.S. Court of Appeals for the First Circuit. Cohen versus Allstate Insurance Company. Contracts, Insurance Law, U.S. Court of Appeals for the Fifth Circuit. AES, Apex Employer Service INC versus Rotondo. Business Law, Contracts, Tax Law, U.S. Courts of Appeals for Sixth Circuit. Castleberry versus Angie List INC, Civil Procedure, Construction Law, Consumer Law, Contract, Supreme Court of Alabama. Green Health LLC, Green EHINC, Southwest Alabama Rural Health Association. Horsham versus Day Service Employer International Union, Local 199 versus State Redistribution Company, Ajmer Bush. Business Law, Contract, Supreme Court of Mississippi. State of X, Newberry, and Honorable Stephen Jackson, Arbitrary Meditation Contracts in Supreme Court of Missouri. And Dallas Fort International Airport versus Vintage Technology Contracts, Government Contracts, Supreme Court of Texas. This is Biochemics INC versus Access Reinsurance Company. Now, Bio INC versus Insurance Company. U.S. Courts of Appeal of First Circuit, docket 17-2059, May 23, 2019. Judge David J. Barron, Areas Law, Contracts, Insurance Law. The First Circuit of affirmed district court's grant a summary of judgments, which district court grants summary judgment to AX Reinsurance Company, AX of plaintiffs. Complaint seeking to the enforced directives of officers' insurance policy with Access, AXIS, holding that the district court did not err in granting summary judgment in favor of Access and denying plaintiff motion to partial summary judgment. Plaintiffs were Biochemics, INC Pharmaceutical Company based in Massachusetts, and John Metz, a persistent and chief executive officer. Plaintiff sought damage of the claim of was AXIS breach. Under the relevant policy has a duty to defend the connection of the investigation conducted in the Security Exchange Commission against biochemists and officers' motion summary judgment. Argued that the breach of the duty to defend the policy because the plaintiffs were seeking to enforce duty relations, a claim that was made before the policies took effect, not covered by the policy, but district court granted the motion and First Circuit affirmed, holding the district court. Now, the plaintiffs were seeking to enforce the duty relation of the claim that was first made before the policy took effect was covered by the policy. The district court granted the motion. First Circuit affirmed, holding the district court and did not err in granting summary judgment to AXIS. Now, this is Cohen. This is Cohen versus Allstate Insurance Company. Courts, U.S. Court of Appeals for the Fifth Circuit, docket 1820330, May 17, 2019, Judge Jerry E. Smith, Areas Law, Contracts, Insurance Law. Now, plaintiffs filed suit against Allstate and its agents in a breach of contract after Allstate refused to pay the claim for flood damage. The Fifth Circuit affirmed the district court judgment in favor of Allstate, holding the district court did not err in granting summary judgment on the breach of contract claim because the claim was barred. The court has held the district court not abused discretion denying petitioner Federal Rule of Civil Procedure 59E motion. Now, AES, Apex Employer Service, INC versus Rotondo. U.S. Court of Appeals of the Sixth Circuit, docket 17-221 slash, comma, 17/2068. May 7, 2019. Judge Thapar. Areas Law, Business Law, Contracts, Tax Law. Rhonda was the sole owner of Apex, which wholly owned 4 limited liability companies. Directionals and entities, Apex Directional Entities, provide services such as human resources to different clients. Rotonda sold directional entitled keys as assets, customers list to the AES, which agreed to pay Rhonda a share of its gross profits in form of consulting fees. 2 entities sought collect Rotonda consulting fees. Occurred loaned money to Rotonda and other companies that had securities interest in Apex assessment judgment against Rotonda Apex of $1.4 million. Rotonda also owes the IRS $3.4 million. IRS filed several notices for the tax lines on Rotonda Apex directional entities. He has filed a interpreter action. This circuit affirmed summary judgment as a favor of the IRS. Timing the federal tax is measured by the IRS gave the motion to the lien 26 U.S.C. 6323A-F, and timing the state securities interest occurring measured when they became chot and incomplete of perfecting occurrence interest would show in 2009 IRS tax. Liens against 2009 court rejected current attempt by recognizing recategorizing customer assets ordinarily belonging to Apex rather than directional entities. This is Castleberry versus Angie List, INC. Supreme Court of Alabama, docket 1180241, May 17, 2019. Judge Sellers, Civil Procedure, Construction Law, Consumer Law, and Contracts. Now, Jesse and Ricky Castleberry appealed a circuit court order dismissing their clients against Angie's List, INC, based on form selection clause in the contract between Angie List and Castleberries. And the Castleberries, who are father and son, became members of the Angie List of 2014. They claim they used a membership with Angie List to locate a contractor, Dream Baz of Alabama, LLC, Dream Baz, which the Castleberries hired renovative bathroom and Jesse Castleberry house to the baked handicap accessible. According to Castleberry, Dream Baz was properly licensed, poorly performed the work of contract to do. Alabama Supreme Court found Castleberry simply pointed out the argument section brief that addition to the suing Angie List, they sued Dreams Baz. They asserted that this action pertains that only agreement between Castleberries and Angie List by improper work performed upon home and located in Montgomery County, Alabama, defend Dream Baz. Castleberry provided discussion specifying claims against Dreams Baz and Angie List. The Supreme Court appeared the Castleberry's claims against Angie List, Dreams Baz were let's see. The Castleberries provide sufficient discussion of specific claims. The Castleberry claims against Angie List of Dreams were based different categories of wrongdoing were only tangibly related. The trial court therefore an error reinforcing form selections clause simply because the Castleberries also sued Dream Baz. Now this is Greenway Health LLC, Greenway EHS Inc. versus Southeast Alabama Rural Association. Supreme Court of Alabama, docket 1171046 hyphen 1171061. May 17, 2019, Judge Michael F. Bolin. Area law is arbitration and mediation, business law, contracts, and health law. Now, Green Health LLC, Greenway EHAINC, formerly EHINC, collectively Green defendants, the Sunrise Technology and Consultants LLC, Lee Investments Consultants LLC, collectively the Sunrise defendants, appealed separately to the circuit court, denying their motions competent or compelled to arbitration. The arbitration of certain claims asserted against them as Southeast Alabama Rural Health Associations, SARHA, because of Alabama Supreme Court determined that the way defendants failed to establish existence of contract containing arbitration provision. The Sunrise defendants' arguments based on intertwining claims therefore also failed. The court therefore affirmed trial court denied and Greenway defendants of the insurance defense motion to stake in proceedings and to compel arbitration. This is Worsom versus Day. Court, Arkansas Supreme Court, citation 2019, Arkansas 160. Opinion, this is May 23rd, 2019. Judge Karen R. Baker, Areas Law Contracts. In the case of Debbie Worsom, was awarded damage to her breach of contract action. Supreme Court affirmed that the judgment of the circuit court denying Worsom's motion to attorney fees and costs, Worsom motion reconsider holding Worsom motion for attorney fees was untimely. An appeal Worsom regarded that was entitled attorney's fee pursuits to Arkansas Code annotated 16-22-308, and that the circuit court erred denying the motion attorney fee because it was timely under Arkansas R. Civil P. 54. Supreme Court affirmed the circuit court denied Worsom motion attorney fees, holding the circuit court correctly found the attorney's fee motion was untimely. Worsom argument that was entitled attorney fees under section 16-22-308 was without merit. The Service Employees International Union Local 199 versus State, Iowa Supreme Court, docket 18-0018, May 17, 2019, Judge Thomas D. Waterman, Area of Law, Contracts, Governments, Administration Law, Labor, Employment Law. The Supreme Court affirmed District Court grant summary judgment dismissing the action filed by public employee union seeking to enforce collective bargaining agreement entered in the Iowa Board of Regiments, holding the Public Employment Relations Board, PRB, acted within the statutory authority promulgating Iowa Administration Code R 621-6.53, which the force of law in district court corrective applied Rule 621-6.53, holding the parties that had enforceable collective bargaining agreement, CBA, with boarding vote ratifying it. The board moved summary judgment of the union action before enforced CBA, relying the Rule 621-6.5, which requires board meeting vote to accept a tentative and voluntary agreement ratifying by the union before a contract become effective. The union argued the agency's was invalid and because it imposed the ratification requirements that are included in Iowa Code 20.174. District Court unfilled agency rule dismissing union enforcement. Supreme Court affirmed holding 1, Rule 621-6.53 is valid. Therefore, enforceable agreements reached without request vote by board to approve the CBA. Rick's Determined Company Inc. versus Anheuser Busch. Supreme Court of Mississippi. Citation 2018-IA 00037-SCT. Supreme Court of Mississippi. May 23, 2019. Judge Izzy. What it is. What it is, Izzy. What it is, Izzy. Areas of law, business law contracts. Now, Rex Distributing Company was a wholesale Anheuser-Busch company, Budweiser. That'd be Chip, and 1313 West Grand at Columbia Center Mall, Simons Mall. Now it is called Kennewick Man. The Kennewick Man remains removed with these bare hands. These beautiful black, white diamond with the gold, silver, platinum, and also they have the settings of a care package with the Tiffany set with pearls, with of course the immaculate golden embezzled diamonds, of course the settings of all assessments, and then busting out the silver and gold regiments, and of course the gold and silver, and also the UBI numbers effectively accurate to the T around all the entitlements and the unities of the services they provide for the services they got in the Supreme Court services. As you can see, and it is 10:50 Friday, February 28th, 2020. It's 10:50 and 59 seconds. It's 10:51 and 3 seconds. Friday, February 28th, on a Friday, 2020. Now, so what it is. Over 13 grounding. Oh yes, I know this guy. I know this Mr. Anheuser-Busch, Mr. Chip, that got a blue shirt says Boeing on it, and also the Kennewick High School on Dayton Street on Kennewick Avenue, which is Mueller's Funeral Home, Chapel Falls, Mueller's Funeral Home in 14 South Union, Kennewick, Washington, which is Kennewick Man. And it would be 1604, 1602 Union Street, the Mid-Columbia Library in Kennewick, Washington. Now, Budweiser, they just have intimate sex. Mr. Bill Gates, this Foundation Microsoft program, now he's an active CEO. Now, Mr. Donald Trump, his services that he provided, of course, him and Roberta Barela have intimate services, intimate coordination. And, of course, this Mr. General Colin Powell is a nuisance to 1313 West Grand, and also the Budweiser Company, which says Chip, and I'll say Bodacious. Now, Bodacious had intimates. Bodacious, he's a PBR road. His name's Frost. He has an only daughter named Jessica, and he only has an only daughter, Jessica. And Jessica, she has a saxophone. I got a violin. I got acoustic guitar, bass guitar, drum set, saxophone, and also a flute, and also those services they got. Don't match the story because everyone loves playing the drums, everyone loves playing the saxophone, everyone likes playing the Gibson guitar, also acoustics, and also the bass guitar, and also the Pearl drum set, which warranties. Mr. Chip loved having sex with Roberta. Bill Gates loved having sex with him, and of course Donald Trump. Oh, they were really. Story after story coming over and going to the churches, Catholic churches, the Mormon churches, and going long distance way to the casinos. Having intimate sex. I'm sure Lola Hernandez watched Mr. Bill Gates take off with Roberta and Lola Hernandez, my grandmother. Watched her take off with Mr. Chip and also Mr. Frost, the cowboy, PBR, professional PBR, right, bull rider, having sex with Roberta. And what came out of that was Jessica. She's only child, and she's my neighbor. Now she owns a PBR, the Levi Company, the Stinson Company, the Boot Company, and Stinson boots, Stinson hats, and also Wranglers, Levi's, and Bodacier armor for. Back in the day, they don't use armor in bull riding. They don't use armor in bull riding either. That's original. Now, services here. The Busch Budweiser, which is Nebraska, Washington. Budweiser, the owner of Nebraska, which is who lives in, which is Buffett, Jimmy Buffett. He lives in Nebraska, and the housing and development we have in Nebraska is in Nebraska. And Budweiser, the guy that owns Budweiser's and the Clydesdales, lives in Nebraska. He owns Nebraska, and he lives in Nebraska, and he does own Budweiser. Chip did his way of trying to break their situation up. Colin Powell, the general of the United States Army, and Desert Storm, and Fallujah, Afghanistan, Kabul, India, Pakistan, China, Japan, they all try and manipulate the situation here. So Mr. Bill Gates is active CEO. Mr. Donald Trump, he's International Mosaic Lake, Washington, which that's me. I'm in the airport, International Airport, and he's outside, and Lynn's outside, and you know how they start yelling and screaming and stuff. But Avak and Mumu Ganja are, of course, growing up, and we're at Simon's Mall. There's Washington State and there's Canada. Washington State and Canada, and there's Washington State and Oregon. And the Nike company is in Oregon, but they know those services and fuel lines and importing exports are for Washed Potato, Lamb Weston, Scona Connor, AM and Irrigation, where that truck built Home Depot, and that truck built Home Depot in Spokane, and built all those big domains and Microsoft companies in Spokane and Idaho. So I guess that's what happens when you have intimate sex and you promise this, promise that. See, but just like Sylvester Stallone leaving his wife because she had cancer, he left his wife because she had cancer. But Sylvester Stallone and people that train people like hospice or terminal ill people, they know that they're losing their children or losing their husband for the duration because they can't satisfy or have any provide services for their husband in their way in a loving, conditional way, unconditional love, meaning that thinner, thicker, thinner blood. Death you depart, richer or poor. That kind of ordeal. See. So, Mr. Court of Supreme Court, Mississippi, citation 2018 IA -000037-CST, May 23, 2018, Areas Law, Business Law. Registered German Company was a wholesaler in Anheuser Buschberg. They have a Budweiser company in Kennewick, Washington. Chip runs a Budweiser, and he ran that company all the way to the of course, until the wheels fall off, until a Barracuda with Mickey Thompson with a brute stick parked at 1319 West Grand Ronde, like Bill Gates with the Porsche, the fastest humankind individual Porsche to mankind. You could put it in a small garage area, and it's very high performance. Takes corners on a dime, and it's a most dangerous vehicle on the planet, fastest vehicle in any residential area. Is a Porsche, and he got that Porsche, and he stands by Department of Licensing and the Soling owner, and they couldn't prove a thing. Abstract record, flawless black record, no prison record, no jail record, never been in jail. None of those circumstances. I crossed the street, basically. Had cash on me and gave it to Eric D. Olson. Gave him $450, another 200 and some bucks. And just kept on giving them money, and they just sitting there and trying to influence and change the system, make things up when I have no record. This is a Freda courthouse right across the street. This is Georgia. My grandmother's on the monument there, and Mr. Bill Gates, he's the active CEO, and of course, that's Donald Trump, Melania Trump, and Vok, Mumu, and all Tiffany, Eric, and Barron, and so forth. This is really individual. This Air Force One landed in Nebraska, and they landed in Washington, and I got baby prints, I got fingerprints, I got portraits, monuments, I got the door frame, the doorbell from originally was put in one spot, in another spot, you know. You got drones flying around, and crooked system. See, this system, they just making things up. They take electrical poles, grunt towers down, and they can't change the system. Nobody changing me. Nobody changing nothing. It says Rex Distributing Company, wholesaler Ajmer Bush, Ren Rex, sought to sell his business. Budweiser asserted a control redirect sale of preferred buyer. Mitchell Distributing Company Rex alleged redirection provision was voided under Mississippi Beer Industry Fair. Now, the Mississippi Beer Industry Fair Filing Act of BIFDA, that Ajmer Bush interference with the sales that caused damages actionable under the same statute. The trial court dismissed Rex claims against Ajmer Bush, and Mitchell was the failure to state claim upon the relief can do. Granted, Mississippi Spring reversed, however, conclude Rex alleged a valid cause of action. It dismissed the Rex of BIFDA against Ajmer Bush and deviate the claims against Mitchell were reversed. The matter remained further proceeding. The Supreme Court affirmed the court a judgment dismissing Rex's other claims. See, unbelievable, huh? GMU Administration Office, we got headstones, head plots, YouTube, Facebook. State versus Raleigh, Newberry, Honorable Stephen Jackson. Supreme Court of Missouri. This is Missouri. Docket SC 96985. Question. Exclamation point. And then SC 96986. May 21, 2019. Judge Patrick Brinkbridge. Areas of law, aberration, and mediation contracts. Supreme Court squashed preliminary writs of issue preventing the circuit court from enforcing orders sustaining motions to compel approbation and state proceeding filed by Dollar General. Holding that the circuit court propelled sustaining Dollar General motions to compel approbation stayed on the causes ordered and parties' approbation question whether consideration existing after Jesse, Newberry, and Barry Lawrence were discharging Dollar General. Filed charges discrimination. Dollar General filed motion to compel Newberry and Lawrence submit their claims of approbation staying under proceeding grounds that employees sign agreements in approbation. Circuit Court sustained Dollar General motions to compel Newberry's and Lawrence each sought a permanent writ of probation prevention. The Circuit Court affirmed enforcing its orders, arguing that Dollar General failed to meet the border of show consideration supporting either employer provision agreements or the provisions delegating therefore threshold issues of probation and applicability. The Supreme Court held on the circuit properly sustained Dollar General's motion to compel approbation and stay cases. Fort Worth. This is Fort Worth, Texas. Dallas Fort Worth International Airport Board versus Vizinti Technologies. Supreme Court of Texas. Supreme Court, Texas, docket 180059, May 17, 2019. Judge Jeffrey S. Boyd. Area law is contract government contracts. Supreme Court reversed the judgment of the Court of Appeals in the part of rendering judgment dismissing claims that governmental entities breached in congressional and contractor promised to make good faith enough to obtain authorized and higher payment, and the parties' written contract required that an entity make lawful government immunities applied that the Chapter 271 Texas Law Government Code that the waive entities immunity. Vinci Technologies sued the Dallas Fort International Airport Board for the Internet and abbreviated contract, alleged that the part that the board failed to make promised good faith effort to authorize, increase, compensate, set forth in parties' contract to bill filed. Employee jurisdiction asserted government immunities buried misaligned claims. The trial court denied the plea of the Court of Appeals, and the Supreme Court denial board plead against the breach of contract claim, holding the government immunity implied in Chapter 271 Texas Law Government Code, waived by board immunity against the claim. Supreme Court reversed that the government immunities buried in Vinci claims against board in Chapter 271 did not waive that immunity. This is McAllen Hospitals LP vs. Lopez, Supreme Court of Texas, docket 17-1733, May 17, 2019, Judge Budsby, Aries Law Contracts. In the breach of contracts filed by employees against employers, the Supreme Court reversed judgment of the Court's appeal, affirmed that the Court rendered a judgment employees taking nothing holding, and there was not legally sufficient evidence that they would have allowed reasonable, fair-minded people and to find the employers and employees and agreed and changed compensation employees from payment based on hours worked, fixed annual salaries. Employees where 4 nurses worked in the McLean Hospitals, LP employer. Employees that are paid based on hours they work. Their lawsuits against employees allege that employers were promised to pay their annual salaries that were breached that agreement. The jury found that the parties had agreed employees would receive fixed amounts of pay. Employee breach agreements, the Court of Appeals affirmed the Supreme Court reversed that the evidence was legal insufficient support jury's finding, and the employer agreed employees in fixed salaries. Now, Mantel versus North Star Energy Construction LLC. This is Court, Wyoming Supreme Court, citation 2019 WY54, opinion date May 21st, 2019, Judge Kate M. Fox. Now, Judge Kate M. Fox and the respondent petitioner serves on the international area of law, business law, and contracts. Now, the services they provide in the Journal of Bot, as Alex Mantel and majority of Mantel Supreme Court affirmed, the part of reverse remand and the part district court decision and various post-trial issues, ongoing litigation arising from sword business deal, and the court held the district court lacking subject matter jurisdiction, offset judgments, and issues pending the Supreme Court Mantel. With respect to Kilmer settlement funds, there are reviewable orders and record regarding the other garlands that stand assert and direct of claim against Carl Clemmer. A mantles that the superior security interests in Kilmer settlement funds and Operation General Envy's clause that FNB security agreements district court nor awarded North Star Energy and Construction LLC attorney in the court their attorney fees and portion of Kilmer settlement funds. The district court in Aaron issued a non-proc order to remove majority mantle name in order to disturb and Kilmer settlement funds. Now, this is Rammel versus Monmere Animal Clinic, PC. Court, Wyoming Court. Citation 2019, WY53, May 21st, 2009. Judge Michael K. Davis. Contracts, Labor, Employment Law, Personal Injury. Supreme Court affirmed the order of the district court entering partial summary judgment against Rex Rammel and the claims against his former employee, Montanary Animal Clinic, PC, its president and its office manager, except Rammel breach express contracts claim that the dismissing the claim and sanction willfully construction of discovery fraud upon the court holding this district court to error, especially the court held deficiencies in Rammel, number 1. Deficiencies in Ramo certification mandate dismissal on appeal. Number 2, defects of Ramo notice appeal did not mandate dismissal. 3, district court and the error entering summary judgment Ramo tortious interference claim. Number 4, the district court not abused discretion dismissed Ramo's breach of express contract claim and sanction as in discovery violations. This is coming to you live here in George Washington House, number 42. Coming to you live. 42, which is straight across from the administration office. As you can see, the services they provide here at the Fair Court, Melissa and the Knight, Larissa President, also Mr. Eric Kurt Slinger, Human Resources Coordinator, and also Ms. Melissa Knight, Assessor, Andy Miller at CO Benton, Washington, U.S. 509-735-3591, 509-7, and Mr. and Mrs. Mr. Felice, J. Felice at Othello, Washington. Mr. Of course, McKinnon Law Firm on Olive in Mose Lake, Washington, and that's Rhonda Kaiser's funeral home right there on that stretch. For the coordinator's signature, that's Frank Kamusco and Rhonda Kaiser's signature, and that's a letter. They're literate, they can read and write, and they're graduated, and they're business owners. Administration office here in George Washington, that's your grandmother and grandfather, great-father, and also the monuments and the headstones there at the Mueller's funeral home. Right across the street, the kennel command that was removed by the service. The Kennedy bodies are on the Mueller's property. The caskets, the hearses that drove, the body of John F. Kennedy and the body assessments, and all the services George Washington House originally is downloaded. See, this is George Washington House and assessments they got going on for the standby equities service they provide. And the services they provide here at the administration office, as you can tell. This is the Court of Arizona Supreme Court. Court of Arizona Supreme Court, which is the background, as you can see, the Freda Courthouse here in Freda, Washington. Of course, Mr. Andy Miller, prosecutor of Benton County, Richland, Pasco, and Kennewick, transport and extradite any criminal in the world. Here in Washington State, on Washington State versus Canada, Washington State versus Oregon. See, Washington State is what it is. So the family laws here, Mr. Barron versus Barron, Court, Arizona Supreme Court, docket number CV-18-0234 PR, May 21st, 2019. Judge Scott Bates, Area Law, Family Law. And this is the, in the divorce case, Supreme Court, vacating portion of divorce, decree providing the order under Colts versus Colts, 148 Arizona 176. 19, holding the federal laws does not permit state court order a military spouse to pay the equivalent of military retirement benefits to former spouse, and the military spouse continues to work past and eligible retirement date. When parties divorced, husband was still an active duty service member. Trial judge ordered the husband to choose to work beyond the retirement eligibility date, begin making payments to his wife, equivalent to that he would have received her share of husband's military retirement pay, MRP. Had husband retired, Court of Appeals reverse include the federal law section increment. The Supreme Court agreed, holding the state courts cannot order service supreme members to say MRP based on payments to former spouse. Why is it big? In any case, and remarriage of George D. Myung, California Courts of Appeal, docket D073667, fourth appeal. Now, May 17th, 2019, Judge Joan Aaron, Area Law, Family Law. Discussion, dissolution proceeding. Stephanie George appeals on an order requiring her to pay $10,000 in sanctioned pursuit of Family Code Section 271 to her ex-husband Daniel Demon, after Demon was required to file a motion for entry of judgment in pursuit of terms of prior settlement. George contends that the family court erred by awarding sanctioning with considering any oral testimony, relying instead of documents submitting, and George support sanctions. The Court of Appeals concluded George's arguments lacked merit. Accordingly, it affirmed the order. In remarriage of Kent, California Courts of Appeal. In remarriage of Kent, Clark Kent, Mr. Superman. You know, George Superman versus Batman. That was a good movie. Superman versus Batman. And the legends of Mrs. where Superman meets Wonder Woman. Superman meets Wonder Woman on the beach of San Luis Obispo. Miss Wonder Woman pronounced herself. And Mrs. Catwoman meets Batman. Miss Catwoman meets Batman, the multi-billionaire versus. See, there's always a breaking point of ramifications of services they provide here. Now, the Court citate the Courts of Appeals, docket D074529. Now, in the marriage of Kent, Clark Kent, in Seattle, Washington. Judge Joan Iran. Area law, civil procedure, family law. Now, Appellate Molly can't challenge a specific ruling at a family court in her request of modifying child custody and child support order issued by a North Carolina court. Family court granted the part of denied and the part of appellate request without first denaming whether the California Court of Jurisdiction under Uniform Child Custody Jurisdiction Enforcement Act UCCGEA. Accordingly, without reaching demerits of arguments related to substantive ruling of the appeal of California Court of Appeal opinion, reversed the order because based on the record before the family in court untimely rule in court lacked jurisdiction to modify the North Carolina order. In the interest of MF, the Supreme Court of Georgia, docket S18, this is the interest of M period F period. Supreme Court of Georgia, docket S18G1338, May 20th, 2019, Judge Bethel. Area of laws, family law. The Georgia Supreme Court granted criteria in the case of address whether the Court of Appeals, and these are Court of Appeals, erred dismissing as moot appealed on juvenile delinquency adjudication M period F. The delinquent of criminal attempt of Aaron Automobile MF placed on probation of 12 months. MF appealed argued the evidence was insufficient in support juvenile court jurisdiction and delinquency. When MF probationary sentence concluded that Court of Appeals issued the order which declines reached the merits of MF's appeal concluded that the case was moot because the probationary sentence was expired. Because the MF has shown recorded an adverse or collateral consequence arising for juvenile courts and jurisdiction and delinquency. The Supreme Court reversed that the holding for juvenile appeals delinquency requirement showing adverse collateral consequences and recurred in the records the consequence should be presumed. The court concluded that Court of Appeals in order reversed was matter remand in consideration on its merits. Child of Radiancy K. Maine Supreme Judicial Court, citation 201 ME 73, May 21st, 2019, Judge Hejram. Areas of law, family law, Native American law. Supreme Judicial affirmed judgment District Court terminating the partial rights of mother and father of child in pursuit of Maine Child Family Services Child Protection Act 22 ME Rev. Stat 4001 to 4099H, the Indian Welfare and the Act of ICWA. 25 U.S.C. S. 1901-1963, holding the District Court that error terminating the parents' parental rights and denying other requests for relief. Special Court held the District Court by concluding the Act efforts that have been made to prevent breaking up Indian family, requiring by ICWA. The evidence is sufficient to support court determining whether personally within meeting of now, especially the court have District Court error concluded the act of effort made and prevent breaking up the Indian family is required. ICWA evidence is sufficient to support the court's determination mothers a personally unit of meaning of the state law. District Court none erred in denying fathers two motions to transfer case in Nation Tribal Court, and the District Court an error denying fathers post-judgment motion and allegedly ineffective sentence of counsel. And Child of Rebecca J. Maine Supreme Court Judicial in Maine Supreme Judicial Court, Citations 2019 ME76, May 21st, 2019, Judge Per Kurum, Areas Law, Family Law. The Supreme Court affirmed Judicial Court, terminating mother's parental rights to her child, holding the mother that had the right to effective association of counsel at the proceeding he or she consented, terminating partial rights and mother received. Effective issuance in the voluntary gave their consent at his hearing. The motion advised court should be a decided consent to termination of the parent rights, satisfy the mother's decision, knowing voluntary court ordered mother and parent rights terminated. Mother later filed a motion trial pursuit and R7P 59 argued consent to the voluntary she received an effective assistance in the counsel giving consent. Court denied mother's request to set also consent. Mother also filed MER Civil P 60B motion of termination based on counsel and alleged ineffective assistance. Court defended the Supreme Court confirmed that holding the court clearly erred, finding the mother voluntary consent and terminating parental rights, are denying the Rule 60B6 motion relief without holding a second evidentiary hearing. Yeah, this is Young versus King. Court, Maine Supreme Court Justice Court, citation 2019 ME78, May 21st, 2019, Judge Andrew M. Mead, Areas of Law, Civil Procedure, and Family Law. The Supreme Court Justice vacated judgment of District Court's dismissed appellate complaint, sinking determined to be facto parent, appellate adopted child, holding District Court erred in dismissing cases of lack of standing. The District Court dismissed appellate complaint lacking standing on appeal. Appellate argued that District Court abused discretion in refusing to holding the hearing and determine the disputed facts of concluding the appellate's refusal to allow appellate to adopt the child's in disposition issue whether appellate behaved and though an appellate had parent to the child. The Supreme Court remanded the case, holding the court treatment of civil appellate refusal of a debault disposition. In the standing analyzed constituted the error in law, the court should have determined disputed facts regarding of, and this is the Maine Supreme Justice Court, citation 2019 ME 78, May 21st, 2019, Judge Andrew M. Mead, Civil Procedure, Family Law. Now, Franditti versus Gold, Supreme Court of Ohio, citation 2019, Ohio, 1959, date which is May 23rd, 2019, Judge Per Kurum, Areas Law, Family Law. Supreme Court affirmed the Court of Appeals judgment denying Carol Fraude petition of writ of prohibition against Joseph Fraude, and the Judge Rosemary Gold Margaret Mitchell Edwards of Chihuahua County Court of Common Pleas Domestic Relation Division, holding the Court of Appeals currently denied the writ of 1990. Carol and Joseph were divorced. The Carol was awarded spouse support in 2017. Just filed in fourth motion. Intermittent modifying count spouse support, which scheduled hearing beginning Mercury Wars. Carol moved when motion dismissed and Judge Gold denied in 2018. Carol filed the okay. 2018, Carol filed the writ of probation, argued that Judge Gold executed his stationary authority permitting Joseph multiple motions to terminate the modifier. Spouse support of the Court of Appeals denied, and the Supreme Court affirmed the holding the Carol was not entitled to the writ. Now, Henry Joseph B., the Court of Rhode Island Supreme Court, docket 17-3428, May 17, 2019, Judge Francis S. Flatner, Area Law, Family Law. This is May 17, 2019. The Supreme Court vacated the decree of family court terminating mother's parents' rights with respect of a minor son. Holding the notice of hearing date, petition to terminate mother's parental rights when a proper matter of law decreed is vacated the matter remand hearing appropriate notice accordance to RI General Law 15-7-9. The family court ordered advertised be placed in newspaper to notify the mother of hearing petition of terminate parents' rights will be held October 3rd, 2017. Mother was now present on October 3rd, 2017. Hearing the court went forward with the hearing despite mother's absence. The trial justice determined that the mother until parent and order of mother parent rights be terminated. Supreme Court vacated remand case of further proceedings holding because there are no affidavit filed evidence of family court in order notice of publication in accordance with RI General Laws 15-7-9. Family court's order advertised was improper matter of law. Number 2, mother is entitled to preclude due process before determination of her parental rights. Now this is the interest of NG, Supreme Court of Texas, docket 18-1508, May 17, 2019, per curum, Judge per curum, Aries Law Family Law. Supreme Court reversed the judgment of the Court of Appeals affirming the trial court termination of mother's personal rights. The mother's personal rights were revoked. No more mother, no more mama, no more mommy will be here no more. Then the holding the Court of Appeals erred, failing to review legal factual sufficiency of evidence to support text. Family Code 161.001b, 1d, and e, finding as grounds for termination and failing to address or specify the order under Section 161.001b, 1, 0, o. The trial court terminated both parents' parental rights under Section 161.001b, 1d, e, and o, and found that the termination was the child's best interest. The Court of Appeals affirmed finding termination sufficient under Section 161.001b, 1, 0, or o, but declining to review legal factual sufficiency of evidence under Section 161.001b, 1d, or e. The Supreme Court reversed remand for further proceedings holding 1 due process that the applicable court detail of an analyzed appeal termination of parental rights under Section 161.001b, 1d, and e, and d. Number 2, the Court of Appeals erred in failing to review a trial order ensure submission of specific warrant termination under Section 161.001b, 1, o. In re-interest of ZMM, Court of Supreme Court Texas, docket 180734, May 17, 2019, Judge per curum, Aries Law Family Law. Parental termination case, Supreme Court, remand the case that the Court of Appeals further proceedings holding the Court of Appeals erred in finding evidence sufficient to terminate father's parental rights, text fam code 161.001b, 1, o, without addressing father's challenge Section 161.001b, 1d. The trial court parental and father's parental rights under the 3 grounds for termination specified in Texas Family Code, Section 161.001b, 1d, n, and o. An appeal of father challenge sufficient evidence in all 3 grounds. The Court of Appeals affirmed the trial court order for termination based on Section 161.001b, 1o. The Supreme Court remanded the case for further proceedings holding 1 in the light of NG SW3 Texas 2019, which the court held due process required appellate court review and detailed. Details on termination of parental rights under Section 161.001b, 1d, and E, when challenging in the appeal court appeals error failing to address father challenge as a Section 161.001b, 1, O, and 2, and the Court of Appeals erred following to address the merits Section 161.001b, D, related to termination of father's parent rights, section 161.001b1, on two parties, mother and father, or departed child with section 1611b, d, and d. Trial court terminate father's parental rights under grounds of termination specified in Family Code section. Texas Family Code sections under 161.001b, 1d, and n, and o. On appeal, father child sufficient evidence on three grounds. This is Pullman versus Chrisley. Court, Utah Supreme Court, citation 2019, U2 18. May 22nd, 2019, Judge Hamanas. Area Law, Family Law. The Divorce Matter Supreme Court affirmed decision in the Court of Appeals upholding the orders of District Court regarding child support. The parent time holding the Court of Appeals properly found that they had limited appellate jurisdiction matter, did not err on upholding the district courts regarding support and parent time. Mothers filed for a decree of 2010. Case dragged out to the better part, decided as the Supreme Court. Father regarded the Court of Appeals, error construing. Notice the appeal that the scope of Court of Appeals appellate jurisdiction erred in affirmed district court orders regarding child support obligations, erred in the affirmed discretion. Court of Order denied the petition to modify, amend, decree. Supreme Court affirmed holding father's notice of appeal, limited that the scope of the appellate jurisdiction. Court of Appeals correctly upheld district court regarding the support, and the Court of Appeals corrective rejected father's arguments regarding his petition to modify. This is Lemus versus Martinez, Wyoming Supreme Court, citation 2008-19, WY52, May 17, 2019, Judge Katz. Areas Law, Family Law. The Supreme Court reversed the order of District Court awarding primary custody of parents, children support, mother, and holding that the District Court abused discretion in order child support with containing sufficient information about father's income. Especially, the court held the court abused discretion in calculated amount of child support based on misunderstanding evidence established father's income. Father's argument, discretion, contort, the presenting deprived of meaningful opportunity, a cross-examination witness failed because of the father's asserting insufficient explaining how district court restriction of the time of held violating due across the term fundamental rights of association with his children. United States versus Felipe Garcia, U.S. Court of Appeals, First Court Circuit, docket 18-1067, apostrophe 18-1116, May 23, 2019, Judge Celia, Criminal Law. First Circuit affirmed judgment of District Court denying defendant's motion to withdraw his guilty of motion related to his sentencing, holding the record without student defendant multiple claims of error. Defendant entered a straight guilty plea to 48 counts of enactment charging with fraud-based crimes. District Court denied defendant's subsequent motion to withdraw plea guilty to other sentencing-related motions. Sentences defendant with 132 months imprisonment in order to make a restitution amount of $7,737,486.10. Their First Circuit affirmed holding the District Court did not abuse discretion in refusing to allow defendant to react his guilty plea. The District Court is erred in applying two-level enhancement crimes involving 10 or more victims. The District Court erred in a calculating amount arbitrating offense of conviction. District Court did not abuse discretion in denying defendant motion. compelled production of materials the days before scheduled sentencing. Now, the defendant motion compelled production materials 3 days before the scheduling sentencing. Number 5, the district court in error denying judge and defendant's motions and eventually hearing the sentence. Number 6, defendant due process, the rights were violated during sentencing. Number 7, where was the plan error in the district court's resolution order? United States versus Pauling. U.S. Courts of Appeal, Second Court, Docket 172539, May 23, 2019. Judge Chin. Criminal law. The government appealed district court's grant defendant motion to vacate portion of jury guilty verdict. Defendant was convicted of conspiracy to distribute 100 grams or more of heroin, as well as several other narcotics and firearm violations. In this case, parties agreed that the government proven beyond reasonable doubt 89 grams of heroin and the attribute of conspiracy. Second Circuit affirmed that the held evidence trial insufficient permanent reasonable jury to find beyond reasonable doubt that conspiracy involved an additional 11 grams of heroin. The court remanded for resentencing. Busby versus Davis. U.S. Court of Appeals for the Fifth Circuit, Docket 15-70008, May 20th, 2019. Priscilla R. Owen. Area Law, Civil Rights, and Constitutional Law, Criminal Law. The First Circuit treated the petition of rehearing and a back petition from panel rehearing pursuit of Fifth Circuit internal operating procedures under Federal Rule of Appellate Procedure 35. The court denied the petition rehearing, withdrew its prior opinion, issued a following opinion, and in its place. The court affirmed this court denial of recorpus of relief to the petitioner convicted of murder and the sentence to death. The court held that under federal law, the actual innocence claims were presented in the success of federal corpus petition. Clearly, concerning evidence standard would apply. Federal law does require states apply a less demanding standard of success of an corpus. Presenting an alternative applying preponderance of evidence standard, the TCCA decision denying petitioner Atkins' claim was based on unreasonable determination of fact and evidence presenting the case. It was an opinion in petitioner intellectually disabled. The court rejected petitioner claims to receive an efficient assistance counsel direct and trial counsel in effectively failing to conduct an adequate sentencing investigation or failing to present an acquitted case during penalty phase of trial. Gonzalez versus Davis. Court of U.S. Appeals of Fifth Circuit. Docket 18-70026. May 17, 2008. Judge Per Kerm. Civil Rights, Constitutional Law, and Criminal Law. Petitioner challenged the district court's denial of petition for corpus relief related to allegedly incompetency to stand trial on capital sentencing. The First Circuit District Court enormously granted the hearing of merits petition claims on denying relief. The court denied sufficient COA because petition claims were particularly barred. And an alternative petition claiming lack of merit because of the evidence brought bear a district court and issued a petitioner competency of 1980 supported by conclusion that reasonable jurists cannot debate the denial of plate claim, reasonable jurist debate claim, discretionary decision claim that the constable provide ineffective assistance claim involving a district court retrospective and compensating hearing was waived. See, the United States versus Randall, U.S. Courts of Appeals of the Fifth Circuit, docket 17-11403, May 26, 2019. Kurt Day Enhard, Judge. Area of law, criminal law. The Fifth Circuit vacated defendant's sentence imposed after pleading guilty to production and transportation of possession of child pornography. As a woman committing felony offenses involving a minor being required, registered sex offender, the court of the district court plainly erred applying USSG 2G2 1D1, created 5 pursued counts in production of child pornography, factoring calculating his total offensive level. Considering the guidelines ranging resulting from district court, watch state guidelines, and this would be, of course, the United States of Randall, and this is the Court of Appeals of Fifth Circuit, watch state guidelines. These services are United States and federal guidelines, United States federal courts. Consideration guidelines ranging resulting from the district court offense and calculating the life imprisonment of the aggravated sentence, 45 years, have been imposed that the properly remedies resentencing, which are accomplished fairly quickly and without extraordinary expense. The court exercised discretionary to remedy a calculation error according to the court remand for resentencing. United States versus Othello. U.S. Courts of Appeals for Circuit Court docket 1840347, May 21st, 2008. Judge Carl E. Stewart. Area law, criminal law. The Border Patrol agents may conduct a canine sniff to search the drugs that concealed alien immigrants and checkpoints so long as the sniff does not length to stop beyond necessary verifier of immigration status. The vehicles of passengers of Fifth District Court denied the motion. The suppressed evidence found guilty at immigration checkpoints, viewing the evidence loss more favorable government and held that the canine sniff did not prolong immigration stop in case defendant disputes that the stop lasted approximately 30 seconds, where Border Patrol agents asked defendant about citizen or cargo travel, which were permissible. Court also noted that the defendant gave valid consent to the search. United States versus Davis, U.S. Courts of Appeals, 6th Court, docket 18-3145, Prostophy 18-3031, May 21st, 2019. Judge Jan Braster Stretch. Area law, criminal law. Davis co-defendant Young contacted 16-year-old SS on Facebook to ask SS her sister trading sex for drugs. SS and her sister drove her to meet Young, said the friends were how to pay for sex. Davis and another man with her car, SS sister, stated that she's 17. Young directed SS sister to drive to Fort Wayne, Indiana, engaged in a prostitution that splitting and proceeding. Young SS drove. SS wrote evening sister returning after Fort Wayne were engaged sex acts and when he asked sex as Davis a young prostitute, and later was convicted of conspiracy of engaging sex and trafficking of minor. 2 counts of transportation of minor, intent of engaging in prostitution, 3 counts of sex of trafficking of minor. The count of 6-year-old age gap between SS Davis implied enactment and undue influence over SS split and Davis offensive conduct of 3 groups. 4 each day prostitution calculating Davis. Now, these 3 counts of prostitution on Facebook and the consideration to pursuing calculating Davis guidelines range of life imprisonment and orally pronouncing sentencing imprisonment. Next day, conveying continuing hearing sentences Davis 316 months imprisonment and sexually affirmed and grouping and Davis offense conducted vacating the sentence and remand the factual findings and related undue influence and enactments and these enhancements. Those are state guidelines and federal guidelines. United States versus Waneta. U.S. Courts Appeal, 6th Circuit, docket 18-1219, May 21st, 2008, Judge Rondell E. Gilman. Area law, constitutional law, criminal law. Waneta was convicted of abuse of sexual conduct, 18 U.S.C. 224485. One of his then 6-year-old son told his grandmother others around could touch properly Ferguson WDW. Her Native Americans lived in the Hastaya Reservation. After mother's death, HDV split their time between Mario grandparents and Washington apartment. Washington denied touching his son, but said the moment's blacks and from drinking did not know what anything might be done to the HDW. Michigan State Police Forensic Laboratories found saliva inside the portion of the underwear touching establishing Silva contained mixture of both HDV. The Sixth Circuit affirmed Washington convicted 288-month sentence, rejecting an argument to circuit court, arguing the AD testifying closed circuit television, upholding district court evidently concerning a testimony of medical provision others HDV. The court upheld district court decision and was the opportunity to present the jury of the video provided between HDB and evidence of suspicious support of conviction. A sentence is probably substantive and reasonable. United States versus Brookman. U.S. Courts Appeals of 8th Circuit, docket 18-1187, May 20th, 2019, Lambisky R. Smith, Area Law, Criminal Law. The 8th Circuit affirmed defendant sentence imposed after pleading guilty be a felon possession of firearm count held at the district court clearly error imposing 4-level sentencing enhancement USSG 2K21B6B possessing firearm in connection with felony offense drug trafficking case of weight packaging of marijuana combined with defendant states the firearm possession constitutes to support district court's conclusion committed the felony offense of drug trafficking. Further, where the fire was found closely approximately to the drugs, the court was held district did not err in denying defendant 3rd level reduction in acceptance and responsibility. U.S. Court Appeal 8th Circuit, docket 181594, 18-1596, May 23, 2019, Stephen M. Coltman. Criminal Law. Insert defendant sentence imposed after pleading guilty on unlawful possession of firearm previously convicted of felony conspiracy of possession of firearm furtherance and drug trafficking crime. Held in district court that they applied cross-referencing under USSG 2K2-1C-1B to USSG 2A1.1 first-degree murder. Guideline where the defendant gave firearm inadequate with the understanding he would use the gun in connection with a drug trafficking activity relating against the woman, eventually killing her. The court was held in the circuit court and Plainfield inclined to declare the sponta of government breach of agreement. This is the Freda Courthouse here in Moses Lake, Washington, Grant County, Warden, Washington, Grant County, Moses Lake, Grant County, and also the service is right here in the George Washington House. This is C Street on 42, and Neighbors is 56, which is the Tabler Wallace, Chadwick's, and the Bar Association. This is the C Street on number 42, George Washington House, and Neighbors, which is 56. Mr. Tabler Schultz, Freda Courthouse here. Melissa McKnight and Larissa Perez and Kurt Slinger, which is Associate Human Resources here in Moses Lake, Washington. The Department license here in Freda, Washington, and also the service of the bride at the Drivers Academy, and also the service of the bride at the administration office here in Mose Lake, Washington, which is Department license here in Clearwater in Kennet, Washington. We'll send this to Andy Miller at CO Benton, Washington. That's Andy Miller at Andy.Miller at CO.Benton, BENTON, at WA, Washington, .US, United States of America. 519-735-3591. Fax at 519